Well, the reaction is still predicated on Section 36 of the Constitution that talks about fair trial. And fair trial is all about adequate time and facility. As one of the senior members of Nnamdi Kanu's legal team, of course, you witnessed that the other day I went to visit him, and my right was violated to an extent that I have to come to court to enforce that right. And the court made a heavy comments against DSS, awarded 5 million naira against them in my favor, asked them to tender apology, and what have you. And at the end of the day, they never complied with that order. So now we can't go to that place. Nnamdi Kanu, as we speak now, there is no conference. I have not had any conference with Nnamdi Kanu as my client, somebody that is facing these huge criminal charges. I have not had any conference with him. I have not been able to discuss with him. I have not even confronted him with evidence provided because DSS is frustrating all my effort to have a conference with him. There is no confidentiality. And we are now asking that the fair trial is predicated on confidentiality. Now that I don't have any confidentiality with my client, how do you want me to enter to take him on trial? It is against the rules of professional ethics for a lawyer to commence a trial with a client that you never prepared for. So, and we are told the judge our predicaments, the evidence are there, and the judge insisted on going on a trial. Trial for what? I would prefer to pull out from the matter than to go into a trial with a client, with a suspect, with the defendant that have not prepared for the trial. So we have provided solutions. We said reinstate his bail as admonished by the Supreme Court. Whether you call it admonition, whether you call it a judgment, whether you call it an obiter, it is a comment of the Supreme Court. And the Supreme Court, once the Supreme Court made a comment, that comment must be put into consideration by the lower court. In making their decision, you should consider it. Reinstate his bail. This man never jumped bail. Or if you say that you don't want to reinstate him bail, send him to Kuje prison or any other detention facility. Because it is obvious that the DSS are the prosecutor. And you can't be a judge in your own case. And every document I am going there with, they normally screen it, search it, go through it before they will allow me. I can't even take any record. I can't even write anything with him. So that is the position. If peradventure on the 20th, he decided to overrule us and insist on keeping Nnamdi Kanu there, he can go ahead with his trial, let him try him, let the DSS be the judge, let them try him and send him to prison or condemn him or whatever thing they want to do. But my very self, I will pull out. I don't know of other lawyers, but I think in consensus we will pull out. And there is no lawyer properly called who will allow his client to go into trial without you preparing that client. You can't even do it in the most the cheapest criminal charges in upper area court. You must give that client adequate time, ask him questions, confront him with documents, and advise him what to plead. Because if I have proper conference with Nnamdi Kanu, I may even advise him plead guilty on this, don't plead guilty on this, based on the facts before me. But I don't have it. I'm empty, and I can't go into trial with such a position. That is the position.
Thank you.
It's my pleasure.